Barry Thomas versus Serenity or Serenity Spearman.
Good afternoon, Your Honor. Andrew Cates, P7829, representing Mr. Barry, who stands to my left. Mr. Barry, please introduce yourself.
All right. Your name?
Good morning. Good afternoon, Serenity Spearman.
All right. Where are we on this case?
Your Honor, this is a termination of tenants case. There's 30 days notice to quit issued to the defendant. We have not come to any sort of a resolution.
All right, pause right here. This is important. What the court is dealing with is a termination of tenancy, not a criminal matter. That means this isn't about guilt or innocence. It's about who has the legal right to stay in the home and for how long. Already, we're setting the stage for a civil power struggle, not a police issue. Keep that distinction in mind. It's going to matter a lot later.
So we are asking for a this time.
Ma'am, what's your position now?
You said what?
What's your position on moving?
Like, where am I at?
Yeah, or do you think that you should have to?
So I wrote something out because I have something that I want to say, but I just don't know how to say it unless I'm reading it because I have social.
Okay, go ahead.
Okay, it'll just take me a short minute. So I couldn't retain a lawyer since the last court date, so I wrote down what I want to say. All I want to say is that we have been together the last roughly 10 days, every single night and almost every day. We've been on great terms. We haven't fought unless the dogs or putting my stuff in storage or court was mentioned. I've had my stepfather at my house taking care of my dogs while I've been with him at his mom's house because he didn't want to come to our house still.
And there it is, the objection. This is the attorney trying to rein things back into legal relevance. Courts don't care about relationship drama unless it directly affects tenancy rights. But here's the twist. Sometimes personal details do explain control, leverage, and housing access. Question for you, where should the line be drawn between legal facts and lived reality?
Because he says he wants some of the dogs gone, which he offered to pay rent for a whole separate house for the dogs and my family. And he says that the thought of me having my male friends over when we weren't on good terms disgusts him. He also wants his...
Objection, Your Honor.
To what?
Is there a legal point to this? I mean, airing out her dirty laundry in open court isn't exactly...
I think your client brought the dirty laundry here. Go ahead, ma'am.
So he said that disgusts him. He also says he wants to set up his cameras and security alarms and have the house completely emptied. And then he wants the house emptied and my stuff in storage, but then he wants me to still live there, which I explained is not a comfortable situation if I can't have my clothes and my stuff in my bedroom. If we're together and I live there, but he can just kick me out and lock the doors whenever he wants. That's the only time we start arguing is when that conversation is brought up. But I've been with him at his mom's house because of what I just explained. We've discussed plans and solutions constantly to get through this together, but we disagree on the time frame. He wants me out within 30 days, but I told him that I could start remodeling my grandma's house where I could live and take my dogs and all my stuff to in March, and it could be completed by April, which is roughly 90 days. He has money invested in the house and he wants his money back, so he doesn't want to wait the extra 2 months.
This is the emotional core of her argument. She's not saying I'll never leave. She's saying I need time to leave safely. In housing court, judges often look for reasonableness, and asking for 90 days instead of 30, especially with a plan, can be persuasive. Do you think stability should outweigh ownership when someone's housing security is on the line?
Wehowever, I need this extra 2 months so I can get my house together, move my dogs and my stuff in my house, and then we can work on us. But we'll only have somewhere, we'll each have somewhere to go in the future. And if I can get a couple more months and get my house remodeled and move all my belongings there, it would save us from all the arguing that we do, and we would be healthy and happy. Tom has helped me every day the last 10 days we've been together. Every day we've been taking care of things. Everything's been lining up, and I've been getting priorities done each day. If we can continue to do good and not argue about court, and if I had a few more months to finish doing what I need to do for myself and for my future, then everything would work out really great. Also, my mom is in this jail, and is supposed to be going to rehab. All her belongings, her stuff is scattered all around the house. So I've just been praying that she'll be home before the end of the eviction process so she can get her belongings and pack her own stuff up so I'm not stuck doing it by myself. She's been there the whole time I've been there. Tom told me today that he would be okay letting you know that he was okay with 30 days, but if I'm being realistic and truthful, I really need 90 days. I could be back at my grandma's house, comfortable, safe, and happy. It would fix a lot of mental illnesses that I've been suffering with the last year. I just want to be back home. I want to feel secure. In 90 days, that could be done, but I need to wait till it gets warmer to start remodeling my house. I still offered to try to pay him, but he doesn't want to take my money because he just wants that. That's all I have to say.
The last case that we had, how did you end up in this house? Because, I mean, what's contained on the complaint, I think, is false.
This is a huge legal moment. Calling someone a trespasser versus a tenant is night and day. Trespassers can be removed quickly, tenants are protected by due process. Even informal permission like being given keys can establish tenancy. This one distinction may have just shifted the entire case.
I ended up
From what? Yeah.
He gave me the keys and I moved all my stuff into the house. My mom was there, my brother was there. He gave them keys. We all walked around. We looked at all the work that needed to be done. Got my cleaning. You know, I had all the puppies. It was 13. They were very young. So I set up everything for the puppies.
So I want to, you can stop there. Counsel, on this complaint, it's alleged that defendant is a trespasser and has no right to be there. I don't even know how he gets to that, if that's the circumstances.
Your Honor, I addressed this at the last hearing. I understand trespasser as a term of art for a legal mind. However, he has asked her to leave, so to him, she is.
On a landlord-tenant summary proceeding, that is not a trespass.
I understand.
Under
that,
any definition, that's not a trespass.
I understand that, Your Honor. My client is brought me onto this case. He had already filed that. The thing is the issue isn't proving a trespass. The issue at hand in this court is that there is a piece of property owned by my client. He has requested it back and he wants possession.
Where he's residing.
He is not residing in the property, Your Honor.
Where they were supposed to reside.
That was the.
So here's my problem, counsel. My problem is, and this was the problem the first time around, is that he somehow or another.
Hugh, that's a judge drawing a hard line. What you're hearing is judicial frustration with what looks like power imbalance disguised as property rights. Judges rarely speak this plainly unless they see a pattern, and this one clearly struck a nerve. Do you agree with the judge stepping in this forcefully, or should the law stay colder and more detached?
Goes into this place with this young lady. My understanding is, at least from what was said, don't know, was that it was bought for her. That's one of her allegations that she has regarding her client. That at some point then, and there's family of hers that's moving into the house. Then at some point he gets sick and tired of her, doesn't like her, doesn't like what she's doing, and she remains constantly under the threat of being evicted. And I think it's correct that what she wants to do is she just wants to have herself, and I think probably the most operative words that she said was where she can be safe and secure. And that's what she's trying to do. Because quite frankly, as I see this, I think your client misled this young lady as to her status vis-a-vis him and vis-a-vis this house. And I'm not going to have a piece in a sort of this almost legal fiction that you can invite these young ladies into your house, be there, and then when you decide you're tired or done with them, just boot them into the street. That's not gonna happen. It's not gonna happen on my watch. So what I think, no, you know what? You can say what you want to say, but you probably don't want to say it to me. So I think what you ought to do, you ought to go out there, talk like civilized human beings, talk to this young lady like she has some value and worth in life. Let her get to the point where she can be safe. That's only going to take a couple of months. Let her do that. She has a plan in mind, and quit like leading her one way, then the other, and then just getting into this court and trying to kick her out, because that's not happening, and certainly not happening, not today. So I'm going to pass this matter. You guys go out there, talk about it, see if you can come to a point at which she'll move out. She says she'll move out. It's just she needs time to do it in an orderly fashion. Pass this case.
Probably good.
All right, you need to talk to them, and then I'm going to call your case back up.
Okay. Oh, okay.
Don't forget your notepad.
Thanks.
Blue Heron Point versus Roderick Casey.
Good afternoon, Your Honor. Rania Haddad for the plaintiff.
Hello, ma'am.
Hello,
Your name?
Sharon Lee.
All right, and you're Mr. Casey's mother.
Correct.
All right. And where are we on this case?
My son had a procedure yesterday, and today he had a follow-up. So that is why he's not here today.
Okay.
And the doctor advised him not to be out and not to make decisions. So today I am here on behalf of him to see if we can get an adjournment.
All right. How much is owing on this?
Your Honor, if I may.
Yes.
Thank you, Judge. I am showing a balance due of $11,168.59. That is inclusive of $10,998.59 in rent to retain and $170 in attorney fees and costs.
Okay.
And so although I do appreciate the nature of the situation, Your Honor, this is the third hearing. This is another adjournment that has been requested. There's been no answer, no attorney on behalf, no affirmative defenses, no motions, no rental payments made since September of 2025. Obviously, no contact with my client. We did attempt to make contact. I do understand that the defendant is potentially in the hospital and is suffering from some medical ailments. However, we can't keep this case open without proper procedure. So we would be seeking
If you say I'm not following proper procedure, I think you better back that down, counsel. I mean, my understanding is he had a lung transplant. Mom came in. I adjourned it out so that they thought a certain course would happen and to even be able to try to deal with it. So I understand why we're here and why it's at this particular point. Ma'am, how is there going to be any payment on this?
I'm not sure. I can't speak on him. For him, I know he'll be able to come out in about 2 weeks. That's why I'm asking for an adjournment.
Okay, let me ask you this though. If he comes out in 2 weeks, he's not going to have the funds to get this paid, right?
I know he can pay something on it. I know that, and he can make arrangements.
Okay, let me ask you this.
Let's zoom out. This second case shows the other side of housing court. Severe medical issues, massive rent arrears, and limited options. The court isn't ignoring compassion, but it can't pause reality forever. Housing court is where empathy and deadlines collide, and someone almost always loses that race against time.
Given everything that he's just recently gone through, what's his long-term plan? Is it to try to remain in these premises? Is it to try to move somewhere else where certain care can come to him or anything else along those lines? Do you know? I mean,
I don't know. He may have to move.
gotcha. Okay. Something tells me ultimately that's what's going to probably transpire.
It
Because I don't
probably
think
will.
he's going to have these funds. This balance isn't going to be getting any higher. And so I'm inclined to adjourn it out 2 weeks. He needs to make a decision. I want you to understand, ma'am, and you can explain this to him, that on the 23rd, unless he has these funds, and I realize you also don't know what funds he has. So somehow you're going to have to get that answer. So it's going to be what funds he has and really if he's going to move, which I think is ultimately what's going to end up happening. Okay. So I'm going to adjourn it to the 23rd. I need an answer to that. Ideally, irrespective of the answer, I'm probably going to grant them a judgment for him to either pay that amount or to move out.
Okay.
Okay?
All right.
So that we're all clear on that.
Your Honor, if
That's
I may.
great.
Yes.
I have a question if, for the defendant's mother, if she's had an opportunity to speak to legal aid on behalf of her son, they could potentially offer some type of services considering the situation. I'm not sure if this court offers legal aid in the court.
No, we do. And I think, I don't know that legal aid would necessarily speak directly with her without getting some permission from him, which is part of the difficulty at the beginning. She came in and was just, quite frankly, she was doing what a mom does. And she's just trying to.
Ma'am, my son could not speak to anyone. He was on
Right.
a ventilator.
He was on a.
He had a double lung transplant.
Right. So what it is if there's. In the interim, and let's put it this way. Coming out of the hospital there should be social workers and others that will be talking to your son about sort of his care afterwards, which will give him a clearer picture.
Yes,
Right.
he has nurses. He has social workers now.
that are doing that and probably will frankly be more advantageous as to where he has to go than would legal services at this point. Okay.
Okay.
So he needs to talk to them about like housing and those kinds of things and his care. Okay. So I'm
Okay.
giving this 2 weeks and I know it's a lot within those 2 weeks, but it sounds like he's at least in yes, Amy.
I'm sorry.
No.
I'm having minutes right now.
Okay. So we have somebody from my court liaison officer that can get in touch with what services might be available for Mr. Casey.
That's great.
Okay. So 23rd at 1 p.m.
One. Okay.
Okay. And so just so that you understand, in some form or another, it's likely next week that in the next 2 weeks, I'm going to grant a judgment or something. All right.
I understand. And I appreciate you so much for being patient in the apartment. Well, thank you for your patience. It's been a rough go.
I know, ma'am. All
Thank
right.
you.
Take care.
All right.
Is that it for you, counsel?
I believe.
Yes.
Thank you, everyone.
All right. Have a good weekend. Brian Danik versus Ruben Peeler.
Good afternoon, Your Honor. Tim QNP 64917 appearing today on behalf of Mr. Danik. Mr. Peeler, to my knowledge, is not here today. Judge, this is a matter that had been adjourned over from December 26th.
Right. On the next available date, and they didn't pay the second service. Would you like to take a default?
I would like to take a default. Thank you.
Raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. Thank you.
Go ahead, sir.
Your Honor, the defendant is currently in arrears to the plaintiff $6,100 in past due rent Further, we have court costs of $205. We are requesting a default judgment of $6,305.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with a writ issue in 10 days.
Thank you, Your Honor. For purposes of some housekeeping, can I submit 3 proposed judgments? I don't have the triplicate form.
3.
Well, just for signature. If I just have one, is that?
I'm only going to sign one.
Perfect.
But if you sign one, we can make a copy for you.
Great, thank you.
Okay. All right.
Thank you.
Thank you. Huron Vista versus Sabrina Jackson.